Why, hello, everyone. Jax West from Stephen Avery Project and Justice with Jax and MAM Gossip on Facebook and Justice with Jax here on YouTube. First, need to thank fellow YouTuber Millbilly, who provided me with the documents that we discussed on yesterday's live. That I said if I was able to get them, that I would go live today at 1 o'clock to read you these documents of Colborn's lawsuit against Netflix. What a waste of taxpayers' money, isn't it? Um, Dude, Netflix didn't do anything to you. You did it to yourself. Hello, Andrea. So I did not read these in advance, even though Millbilly sent them to me yesterday. So I had plenty of time that I could have read it. But in the past, I like to read filings, and there's Millbilly. Thank you very much. I like to read the filings for the first time when I read them with y'all because then however I'm feeling about it at the moment that I'm seeing it for the first time, I prefer to, just be covering it there. Sup, Cat, and hello, Kim. So when there is some gobbledygook in a filing, when like they're citing other cases, thumbs up, Nana, thank you. Um, So when they're citing other cases, because it's something that I hate about our system here in the States, is in order to get things into court, there has to be another case that had something like this happen, which I'm like, that's just to me ridiculous because, you know, cases are different. I don't know why you have to have something from before to be able to do it. But so when there are other cases that they're citing that they talk about, I just skip that because who cares? And if you want to go in depth on that, then you can get it and read it all for yourself. Um Same thing for a lot of times, and I know, oh my gosh, I have made people so upset in the past for doing this, but I am who I am, so whatever. But when you're reading um something that's got a lot of numbers in it, that this file blah 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 or this law blah 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 point blah blah, I say blah blah. I don't sit there and read all the numbers cuz do you really care about all those numbers? So I just say blah, blah, blah. And people are like, that's so unprofessional. I'm not a professional, dudes. I'm just somebody who's on YouTube, so it's going to be blah, blah, blah. While I'm reading, I'll try and go look back and forth to see what comments are on here, but I may not see your comment. So don't think I'm ignoring you. I'm reading over here. So, all right. So this document is in the United States District Court for the District of Wisconsin, Milwaukee Division. Andrew L. Colborn, plaintiff, versus Netflix Inc. and all the different companies that were involved in this. And then it also says Laura Riccardi and Moira Demos, the documentarians. Declaration of Lita Walker. Lita, Leita. I, Lita Walker, under penalty of perjury and subject to blah, 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 declare as follows. 1. I am one of the attorneys for defendant Netflix Inc. in the above captioned action. I have personal knowledge of the matters set forth herein. I make this declaration in support of Netflix's motion to compel production of documents responsive to subpoena to Michael Griesbach. 2. No worries, nobody's late. 2. Attached here too as Exhibit 1 is a true and correct copy of the subpoena to produce documents, information, or objects, or to permit inspection of premises in a civil action to Michael C. Griesbach, as served on Mr. Griesbach on February 10, 2022. 3. Attached hereto as Exhibit 2 is a true and correct copy of the objection to defendant Netflix Inc.'s subpoena to attorney Michael Griesbach as served by counsel for Mr. Griesbach on Netflix Inc. on February 24, 2022. And so this is the end of the first page. And so on the bottom, it's telling you this is page one of, well, this says it's page one of two, but that it was filed on March 22nd, 2022, and it is March 24th. All right. 4. Attached hereto as Exhibit 3 is a true and correct copy of a March 8, 2022 letter sent by me to John F. Mayer, counsel for Mr. Griesbach in this matter, regarding Mr. Griesbach's objections to the subpoena and seeking an opportunity to meet and confer regarding Mr. Griesbach's objections. I object. 5. Attached hereto as Exhibit 4 is a true and correct copy of email correspondence between myself and Mr. Mayer regarding the scheduling of counsel's meet and confer, as well as correspondence exchanged after counsel's meet and confer. 6. Attached hereto as Exhibit 5 is a true and correct copy of email correspondence produced by the Manitowoc County Sheriff's Department in response to a subpoena served by Netflix Inc., Bates Swamped, stamped Manitowoc, and a bunch of numbers, blah, blah, blah. 7. Attached hereto as Exhibit 6 is a true and correct copy of a document produced by the Manitowoc County Sheriff's Department in response to a subpoena served by Netflix Inc., Bates, stamped Manitowoc, blah, blah, blah. 8. Attached hereto as Exhibit 7 is a true and correct copy of email correspondence sent by Mr. Griesbach to producer defendants Laura Riccardi and Moira Demos, which I obtained from counsel for the producer defendants. 9. Attached hereto as Exhibit 8 is a true and correct copy of excerpts from the deposition transcript of September 22, 2005. Mr. Griesbach in Avery versus Manitowoc City, number 4, blah, blah, blah. I declare under penalty of perjury that the foregoing is true and correct, dated March 22, 2022, and signed by Lito Walker. Exhibit 1. Subpoena to produce documents, information, or objects, or to permit inspection of premises in a civil action to Michael C. Griesbach. And then the box is checked before production. You are commanded, which is in all capitals and all bold, to produce at the time, date, and place set forth below the following documents, electronically stored information, or objects, and to permit inspection, copying, testing, or sampling of the material. Please see attached Exhibit A. And then it's listing a lawyer's office in Milwaukee for the place. And the date and time would be March 11, 2022 at 10 a.m. And then it is signed by the attorney's signature, blah, 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 proof of service form, federal rule of civil procedure instruction form. So a lot of nothing to read. Exhibit A. Pursuant to the attached subpoena, you are commanded to produce the following documents, electronically stored information, or tangible things in your possession, custody, or control. Definitions and instructions. The following definitions and instructions shall apply to the document requests herein. Notwithstanding any definition below, each word, term, or phrase used in these requests is intended to have the broadest meaning permitted under the Federal Rules of Civil Procedure. Instructions. 1. You are obligated to produce all responsive documents in your possession, custody, or control. This means that you are obligated not only to conduct an adequate search for responsive documents that you currently possess, but also to make the same fulsome search for all responsive documents that are in your custody or control. This obligation requires you to search for all responsive documents that you have a legal right to obtain from any source, including documents that are currently in the possession of third parties, such as bankers, accountants, physicians, attorneys, agents, representatives, employees, or government agencies. 2. If you cannot respond to any document request in full after exercising due diligence to secure the requested information, so state an answer to the extent possible, specifying the reasons for your inability to answer the remainder and stating whatever information or knowledge you have concerning the unanswered portions. 3. If any document or portion thereof which falls into the scope of the requested documents is withheld from inspection or production, the document or portion thereof shall be identified, and the reasons for withholding such documents or portion thereof shall be stated. The identification of the document or portion thereof shall include 1. The date of the document, 2. The author or originator of the document, 3. The person or entity to whom the document was addressed, 4. The name of each person or entity who was provided with a copy or had access to or examined the document, 5. The type or title of the document, 6. The general subject matter of the document, and 7. The present location of the document and the name of the custodian thereof. For any document which is the subject of a claim of the attorney client privilege or attorney work product, the grounds upon which the claim of privilege or attorney work product is made shall also be stated. 4. In accordance with the provisions of Federal Rule blah blah blah, the requested documents shall be produced as they are kept in the usual course of business or shall be organized to correspond with the categories in the requests. 5. In accordance with the provisions of Federal Rule blah blah, when a document request calls for the production of electronically stored information, you should produce the material in both a PDF or TIFF image format with a document control number associated with each page of such images, as well as in the native format of the material so that all associated metadata is also produced with the electronic file. So no hiding by sending them stuff in a way that you have to have a special program to open. 6. Unless otherwise specified, each request calls for production of documents created on or after January 1, 2002 and before October 1, 2018. 7. Attached hereto as Exhibit B is a true and correct copy of the protective order entered by the court in this action for your reference. Definitions. 1. The use of the singular form of any word includes the plural and vice versa. Oh my God, do you really have to go through stuff that tedious? 2. The words and when I do this, it's because there's quotes around the word, not because I'm being a douchebag and using air quotes. So the words and, or, and or should be construed conjunctively or disjunctively as necessary to make the discovery requests inclusive rather than exclusive. 3. The terms each, any, and all mean any and all or each and every and should be construed to make the discovery requests inclusive rather than exclusive. My God, this is so tedious. 4. The term including should be construed to make the discovery requests inclusive rather than exclusive. 5. The term communication means any form of communication, including in-person oral communications, meetings, and or witness consultations, telephone conferences, transcripts of such meetings or telephone conferences, emails, text messages, letters, notes, memoranda, or any transcript of information, inquiries, ideas, facts, opinions, or thoughts by any means at any time or place under any circumstance. Oh my gosh. 6. The term document is defined by the synonymous in meaning and equal in scope to the usage of this term and federal rule blah blah, including without limitation all communications as defined above: emails, text messages, letters, correspondence, memoranda, papers, records, notes, diaries, reports, phone logs, calendars, day timer, and appointment book entries. Whose appointment book? Um, I know. Information contained on computer or other electronic storage, metadata, compilations, ledgers, tape recordings, telegrams, summaries, electronic or computerized data compilations, and any other document as that term is used in federal rule blah blah and rule blah blah of the federal rules of evidence. All original documents, file copies, and all other copies, drafts, or non identical copies of such documents or prepared in connection with such documents, no matter how or by whom prepared, and whether used or not, are separate documents within the meaning of this term. 7. The term concerning means relating to, referring to, describing, evidence, or evidencing, or constituting. 8. The terms regarding, related to, relating to, and or referring to mean constituting, containing, embodying, reflecting, identifying, incorporating, summarizing, mentioning, dealing with, supporting, or in any way pertaining to the particular request. I mean, they're really making sure there's no way you can weasel around it. They are giving you every possible meaning of a word. The term person means a natural person, firm, association, organization, partnership, business, trust, corporation, public entity, or any other kind of business or legal entity. 10. The phrase any person or persons acting on your behalf includes, but is not limited to, agents, contractors, subcontractors, attorneys, employees, expert witnesses, and investigators, whether hired or appointed by you, your attorneys, or their representatives, or by a court of law. 11. The term identify, when referring to documents, means to give, to the extent known, the 1. Type of document, 2. General subject matter, 3. Date of the document, and 4. Author or plural. It's got the little parenthesis and the S for the authors, addressees, and recipients. 12. The term making a murderer means the documentary television series first released by Netflix on December 18th, 2015. 13. The term producer defendants refers to Laura Riccardi, Moira Demos, and Chrome Media LLC, um, FKA, formerly known as Synthesis Film LLC. 14. The terms plaintiff or Colborn refer to the plaintiff in this matter, Andrew L. Colborn. 15. The term books refer to the books Unreasonable Inferences, the true story of a wrongful conviction and its astonishing aftermath, 2010. The Innocent Killer, a true story of a wrongful conviction and its astonishing aftermath, 2015. And Indefensible, the missing truth about Stephen Avery, Teresa Halbach, and Making a Murderer, 2016. 16. The terms you, your, yours mean you and any and all of your agents, employees, contractors, subcontractors, or any persons acting on your behalf. Got all that? Document requests. 1. All documents drafted in connection with the books, whether formal or informal, including outlines, treatments, and draft and final manuscripts. Yeah, yeah, that's true, Jeff. 2. All documents and communications which you consulted, relied upon, sent, received, or used in writing the books. 3. All documents and communications regarding, related to, including, or consisting of any drafting, editing, or fact checking of the books. Let me pause here. I've put my little cursor on number 4, so hopefully I'll remember. Millbilly saying he opened a can of worms. When I organized the first June Manitowoc rally and was going through all the crap there when Manitowoc was trying to prevent me from doing it and going against my constitutional right for um um to my right for a peaceful protest. And I got the Wisconsin ACLU involved. And so then the Wisconsin ACLU then asked me if they could talk to Manitowoc on my behalf, and yes. And so they then ordered Manitowoc to give them, so it was like this. It was anything in any form, anytime my name was mentioned anywhere, they had to turn it over to the ACLU. So, roll. 4. All documents and communications regarding, related to, including, or consisting of marketing and promotion of your books. 5. All documents and communications regarding, related to, including, or consisting of your opinions regarding and reaction to Making a Murderer. 6. All communications between, among, or involving Ronald Goldfarb regarding your books, Making a Murderer, Netflix, or the producer defendants. Who's Ronald Goldfarb? Somebody Google him. 7. All documents and communications regarding or related to Making a Murderer, including but not limited to all communications with the producer defendants. 8. All documents and communications regarding, related to, consulted, or drafted as part of the Attorney General and Department of Criminal Investigation review of the prosecution of Stephen Avery for the rape of Penny Bernstein. He invented the clarinet. Okay, Jeff. Including the 2003 exoneration of Stephen Avery. 9. All documents and communications consulted in preparation for your September 22, 2005 deposition in the civil lawsuit Avery versus Manitowoc County. 10. All documents and communications consulted in your preparation of the initial search warrant for the Avery property, as described in Innocent Killer at 221. A Washington attorney. Thank you. 11. All correspondence between, among, or involving. Here we go. I'm going to assume these are all, looks like all lawyers of some sort here. Keep an eye on the bridges. James Bolger, James Buting, Lisa Khalif, Risa Evans, Norm Gahn, Stephen Glynn, Robert Henek, Len Kaczynski, Meow, Walter Kelly, Tom Kosorik, Ken Kratz, Peg Lautenschlager, Kenneth Peterson, Dean Strang, or Dennis Vogel regarding Penny Bernstein, Teresa Halbach, Stephen Avery, your books, Making a Murderer, Netflix, or the producer defendants? Bam. Exhibit B, protective order. Based on the stipulation of the parties and the factual representation set forth therein, the court finds the exchange of sensitive information between or among the parties and or third parties other than in accordance with this order may cause unnecessary damage and injury to the parties or to others. The court further finds that the terms of this order are fair and just, and that good cause has been shown for entry of a protective order governing the confidentiality of documents produced in discovery, answers to interrogatories. Is that how you say that? Interrogatories? That's a weird word. Answers to requests for admission and deposition testimony. It is therefore ordered that, pursuant to federal blah, 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 A, designation of confidential or attorney's eyes only information. Designation of information under this order must be made by placing or affixing on the document or material in a manner that will not interfere with its legibility. Legibility. The words confidential or attorney's eyes only. 1. One who produces information, documents, or other material may designate them as confidential when the person, in good faith, believes they contain trade secrets, or non-public, confidential, technical, commercial, financial, personal, or business information. 2. One who produces information, documents, or other material may designate them as attorney's eyes only when the person in good faith believes that they contain particularly sensitive trade secrets or other non public, confidential, technical, commercial, financial, personal, or business information that requires protection beyond that afforded by a confidential designation. 3. Except for information, documents, or other materials produced for inspection at the parties' facilities, the designation of confidential information as confidential or attorney's eyes only must be made prior to or contemporaneously, said that one, with their production or disclosure. In the event that information, documents, or other materials are produced for inspection at the parties' facilities, such information, documents, or other materials may be produced for inspection before being marked confidential. Once specific information, documents, or other materials have been designated for copying, any information, documents, or other materials containing confidential information will then be marked confidential after copying, but before delivery to the party who inspected and designated them. There will be no waiver of confidentiality by the inspection of confidential information, documents, or other materials before they are copied and marked confidential pursuant to this procedure. Yeah, this is long-winded, Cat. 4. Portions of depositions of a party's present and former officers, directors, employees, agents, experts, and representatives will be deemed confidential only if designated as such when the deposition is taken or within 30 days of receipt of the deposition transcript. 5. If a party inadvertently produces information, documents, or other material containing confidential or attorney's eyes only information without marking or labeling it as such, the information, documents, or other material shall not lose its protected status through such production, and the party shall take all steps reasonably required to assure its continued confidentiality if the producing party provides written notice to the receiving party within 10 days of the discovery of the inadvertent production, identifying the information, document, or other material in question, and of the corrected confidential designation. B. Documents and use of confidential information Information, documents, or other material designated as confidential or attorney's eyes only under this order must not be used or disclosed by the parties or counsel for the parties or any persons identified in subparagraphs B1 and 2 below for any purposes whatsoever, other than preparing for and conducting the litigation in which the information, documents, or other material were disclosed, including appeals. The parties must not disclose information, documents, or other material designated as confidential to putative. Is that word? Putative class members not named as plaintiffs in putative class litigation unless and until one or more classes have been certified. Nothing in this order prohibits a receiving party, that is a government agency, from following its routine uses and sharing such information, documents, or other material with other government agencies or self regulatory organizations as allowed by law. 1. Confidential information. The parties and counsel for the parties must not disclose or permit the disclosure of any information, documents, or other material designated as confidential by any other party or third party under this order, except that disclosures may be made in the following circumstances. A. Disclosure may be made to employees of counsel for the parties or, when the party is a government entity, employees of the government who have direct functional responsibility for the preparation and trial of the lawsuit. Any such employee to whom counsel for the parties makes a disclosure must be advised of and become subject to the provisions of this order requiring that the information, documents, or other material be held in confidence. B. Disclosure may be made only to employees of a party required in good faith to provide assistance in the conduct of the litigation in which the information was disclosed, who are identified as such in writing to counsel for the other parties in advance of the disclosure of the confidential information, documents, or other material. C. Disclosure may be made to court reporters engaged for depositions and those persons, if any, specifically engaged for the limited purpose of making copies of documents or other material. Before disclosure to any such court reporter or person engaged in making copies, such reporter or person must agree to be bound by the terms of this order. D. Disclosure may be made to consultants, investigators, or experts, collectively experts, employed by the parties or counsel for the parties to assist in the preparation and trial of the lawsuit. Before disclosure to any expert, the expert must be informed of and agree to be subject to and held in confidence. E. Disclosure may be made to deposition and trial witnesses in connection with their testimony in the lawsuit and to the court and the court staff. F. Disclosure may be made to persons already in lawful and legitimate possession of such confidential information. 2. Attorneys' eyes only information. The parties and counsel for the parties must not disclose or permit the disclosure of any information, documents, or other material. I'm going to now end up starting to do more blah 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 because it's becoming, there's a 49 pages. We're on 18 of 49, and a lot of this is just saying the same thing over and over. So, I'll start skipping stuff that's way repetitive. Um, so, um, except that disclosures may be made in the following circumstances. A. Disclosure may be made to counsel and employees of counsel for the parties who have direct functional responsibility for the preparation and trial of the lawsuit. Any such employee to whom counsel for the parties makes a disclosure must be advised of and blah, blah, blah. So they have to know the order and hold it in confidence. There's again for this is the court reporters thing that was just said, and then the next paragraph is experts. Um, Disclosure may be made to deposition and trial witnesses. Disclosure may be made to persons already in lawful and legitimate possession of such attorney's eyes only information. And Millbilly says discovery to be completed by April 8th, expert discovery to be completed by, oh my gosh, what is that, September 6th? Motions due by June 24. Final pretrial and trial dates to be set at later date. Gross. I hate that this stuff can drag out so long. C. Maintenance of confidentiality. Expert as provided in subparagraph B, counsel for the parties must keep all information, documents, or other material designated as confidential that are received under this order secure within their exclusive possession and must place such information, documents, or other material in a secure area. You can't apply to be jurors. If you get sent a jury summons at that time, maybe, but yeah, you can't, but you can go. Um, C, maintenance of confidentiality. Did I just read that? Yes, I did. 1. All copies, duplicates, extracts, summaries, or descriptions hereinafter referred to collectively as copies, making copies of information, documents, or other material designated as confidential under this order, or any portion thereof, must be immediately affixed with the words confidential or attorney's eyes only, blah, blah, blah. 2, to the extent that any answers to interrogatories, transcripts of depositions, responses to requests for admissions, um, or any other papers filed or to be filed with the court reveal or tend to reveal information claimed to be confidential. These papers or any portion thereof must be filed under seal by the filing party with the clerk of court, utilizing the procedures set forth in general blah blah. If a court filing contains information, documents, or other materials that were designated confidential or attorney's eyes only by a third party, the party making the filing shall produce notice of the filing to the third party. D. Challenges to confidentiality designation. A party may challenge the designation of confidentiality by motion. The movement must accompany such a motion with the statement required by civil law, blah, blah. The designating party bears the burden of proving that the information, documents, or other material at issue are properly designated as confidential. The court may award the party prevailing on any such motion actual attorney fees and costs attributable to the motion. Conclusion of litigation. At the conclusion of the litigation, a party may request that all information, documents, or other material not filed with the court or received into evidence and designated as confidential or attorney's eyes only under this order must be returned to the originating party or, if the party so stipulate, destroyed unless otherwise provided by law. Notwithstanding the requirements of this paragraph, a party may retain a complete set of all documents filed with the court, subject to all other restrictions of this order. Dated at Milwaukee, Wisconsin on August 19, 2021. And it's signed by Brett Ludwig, United States District Judge. Exhibit 2, we're on page 20 of 49. Objection to defendant Netflix Inc.'s subpoena to attorney Michael Griesbach. Michael Griesbach, by his attorneys Mayer, Graff, and Wallace, hereby objects to defendant Netflix Inc.'s subpoena for the production of documents pursuant to federal blah blah. The objections include, but are not limited to: 1. Mr. Griesbach is counsel of record for plaintiff Andrew L. Colborn. uh, Defendant Netflix, has served a subpoena pursuant to Rule 45 on Michael Griesbach for a barrage of information related to a number of books that Mr. Griesbach wrote about his impressions of the Netflix series Making a Murderer and the subjects discussed within the series. Mr. Griesbach is not a witness in this matter, nor shall he be permitted to become one, as it simply would not further this matter. Mr. Griesbach's books are simply his own impression, meaning lies, of the issues and have no bearing on this case. 2. The evidence is not relevant pursuant to federal blah, blah, blah. Mr. Griesbach's books are based entirely on lies. No, sorry, on his own impressions of publicly available records. There is nothing which Mr. Griesbach could provide in this matter that would further this matter, and nothing which is original evidence. Blah, blah provides that evidence is relevant if it, quote, or if, quote, it has any tendency to make a fact more or less probable than it would be without the evidence, and the fact of consequence is determining the action, unquote. The evidence which Netflix seeks is not relevant per this standard. Mr. Griesbach relied exclusively on publicly available records, the same records that the Netflix series is based on. There is simply nothing which Mr. Griesbach could provide which is not already available to Netflix, and thus nothing that would have any tendency to make a fact more or less probable. Well, if you say that, then what's the big deal about turning it over, right? So just turn it over. Easy. 3. Hello, Mary. The requested information is protected because of its proprietary nature. These requests seek evidence that is otherwise available. Oh, I forgot. That was number 4. 5. These requests seek information and material that could never be admitted into evidence. 6. These requests are overbroad and unduly burdensome. 7. Mr. Griesbach has no special knowledge concerning the evidence in the Hallbach investigation. He relied on publicly available documents, including court filings, the court's written decisions and orders, hearing transcripts from court proceedings, including the transcripts from the 6-week-long jury trial, and the transcripts from Netflix's Making a Murderer. There's transcripts? 8. All the evidence is available to the defendants without the obvious effort to turn a plaintiff's attorney into a witness for its prejudicial effect. No, if you have it all already, less work for people. Be a peach. Dated 24th day of February, 2022. And it is signed by John Mayer, who is attorney for Michael Griesbach. And he's an attorney in Wisconsin. And did you know Wisconsin is the only state that you do not have to pass the bar to become a lawyer? So, sorry, Wisconsin, but what does that say about how smart your lawyers are there? Exhibit 3 is an email. Ballard Spar, LLP in Minnesota. Oh, that's that Lita Walker. March 8, 2022, via email to John F. Mayer regarding Colborn versus Netflix. Dear counsel, as you know, this firm represents defendant Netflix in the above captioned litigation. The litigation. He only read the transcripts. Yeah, okay. On February 10, 2022, Netflix served on your client, Michael Griesbach, a subpoena for the production of documents pursuant to Federal Rule of Civic Procedure 45, the subpoena. The subpoena sought 11 categories of documents and communications, all of which relate to matters central to this litigation, namely the extent to which Making a Murderer is a substantially accurate depiction of the events underlying it, how viewers, including Mr. Griesbach, oh boy, um, I'm getting screenshots of, I'm assuming the Boston douche talking shit about me. Um, where was I? All of which relate to matters central to this litigation, namely the extent to which Making a Murderer is substantially accurate depiction of the events underlying it, how viewers, including Mr. Griesbach, reacted to Making a Murderer, and how Making a Murderer impacted the reputation of plaintiff Andrew Colborn, if at all. On February 24, you submitted objections to the subpoena on Mr. Griesbach's behalf. The objections. On that basis, Mr. Griesbach has withheld all documents responsive to the subpoena. Mr. Griesbach's objections can be categorized as follows. 1. The subpoena seeks information that is inadmissible and not relevant to this case according to the standard set by Federal Rule of Evidence 401. 2. The subpoena is overly broad and unduly burdensome. 3. The subpoena seeks information that is both public or otherwise available to Netflix, but at the same time protected because of its proprietary nature. And 4. Because Mr. Griesbach is now counsel of record, his firsthand knowledge of the events which underlie Making a Murderer and which predates his notice of appearance in this case is suddenly beyond reach of discovery. For the reasons explained below, however, these objections lack merit. We therefore write to request that you withdraw the objections and promptly disclose all documents responsive to the subpoena so that Netflix is not forced to bring a motion to compel. 1. The objections are waived in light of their reliance on boilerplate language. The objections consist of boilerplate language without specific factual or legal authority. None, and that's italicized, of the objections address the subpoena request individually to explain why a particular request is improper. Such note facially deficient objections are tantamount to no objections at all, and then a case that it's citing. 2. The objections ignore the scope of discovery under the federal rules of civil procedure. Mr. Griesbach objects to the subpoena on the ground that, quote, the evidence is not relevant pursuant to Federal Rule Evidence 401, unquote. Objection. 2. He also objects that the subpoena, quote, seeks information and material that could never be admitted into evidence, unquote. Objections. Neither objection is valid. Quote, information within the scope of discovery need not be admissible in evidence to be discoverable, unquote. And then it's citing a whole bunch of different cases. The subpoena easily clears this low bar, as shown by even a cursory comparison of Mr. Colborn's second amended complaint and Mr. Griesbach's books. For example, Mr. Griesbach writes of conversations he had with Mr. Colborn regarding the telephone call Mr. Colborn received while working at the Manitowoc County Jail. He also writes about drafting the initial search warrant for the Avery property and about the strange coincidence of the timing of Mr. Colborn's and Jim Lang's depositions in Mr. Avery's civil lawsuit and their finding Ms. Halbach's car key in Mr. Avery's bedroom. He also writes about public reaction to Mr. Avery's exoneration and subsequent arrest and trial for Ms. Halbach's murder and how people's opinions toward Mr. Avery didn't evolve. Yeah, I would say that's all very important information. Yeah. Um, these are but a few examples of many demonstrating why Netflix requests are reasonable, relevant, and proportionate to the needs of this case. As such, there is no basis for a relevance objection, and Mr. Griesbach is obligated to promptly produce all responsive material. Yeah, so how come they think or Griesbach thinks he can get out of this because he's the attorney instead of it being he has to recuse himself and he can't be the attorney? 3. The subpoena is neither overly broad nor unduly burdensome. Mr. Griesbach states his entire overbreadth and undue burden objection in a single conclusory sentence. Quote, the requests are overbroad and unduly burdensome. Unquote. Objections. Blah, blah, blah. I'm not gonna go through and read, all the stuff that was already up above. Here, Mr. Griesbach made no showing, specific or otherwise, as to how the subpoena would burden him. 4. Mr. Griesbach's conflicting objection that the subpoena seeks information that is both public and proprietary itself demonstrates that this objection is invalid. Next, the objections claim that blah, blah, blah. So it's going through his, um, okay. I'm scanning through this to find, um, something that's not in there that we've already read. We know that in November 2005, Mr. Griesbach had a private meeting with Ken Kratz, Mark Rohr, and Detective Wiegert, resulting in the decision to draft a search warrant for the Avery salvage yard. It is thus apparent that Mr. Griesbach has non public information that is relevant to this case. Boom. What's more, Mr. Griesbach simultaneously claims that he, quote, relied exclusively on publicly available records, the same records that the Netflix series is based on, unquote, and that the, quote, the requested information is protected because of its proprietary nature, unquote. These objections are mutually exclusive, and your failure to specify which requests you believe seek publicly available information and which seek purportedly proprietary information is sufficient to find waiver of both. In any event, the purportedly proprietary nature of the information is insufficient ground to withhold discoverable material. Attached as Exhibit B to the subpoena was the protective order in this case. The protective order contemplates that a producing party may designate responsive material, and here we go through all the confidential and eyes only thing. In other words, it is not permissible for Mr. Griesbach to withhold relevant, responsive material because of its allegedly proprietary nature. And to the extent Mr. Griesbach is withholding documents based on the incorrect notion that, quote, there is simply nothing which he could provide which is not already available to Netflix. Da, 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 um, 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 um. Okay. 5. Mr. Griesbach is and has always been a material fact witness in this case. The objections make several claims that, quote, Mr. Griesbach is not a witness in this matter, nor should he be permitted to become one. Notably, Netflix has not yet served a deposition or trial subpoena upon Mr. Griesbach. It has simply requested he produce various documents. But respectfully, assertions that Mr. Griesbach is not a witness in this matter are patently false. Mr. Griesbach's role in the underlying events long predates his representation of Mr. Colborn in this litigation. And then there's a footnote. The footnote says, quote, if only I had not been involved in the Avery story myself, perhaps then I could have simply enjoyed the craftsmanship, unquote, of making a murderer, Michael Griesbach in his book Indefensible. Bam. And any suggestion to the contrary is but a feeble attempt by Mr. Griesbach to avoid his obligations as a fact witness. That he has personal knowledge of and relevant discoverable material related to matters of the very heart of this litigation is readily apparent throughout his books. Beyond those examples already provided above, in The Innocent Killer, which was originally published in 2014, more than a year before the release of Making a Murderer, Mr. Griesbach details that he was the first person to discover information about Gregory Allen in the Stephen Avery files of the Manitowoc County District Attorney's Office. And then it tells you what page number in the book. that he directly communicated with the Wisconsin Innocence Project, which was representing Mr. Avery, that he was one of only two people in the room when the DNA analyst at the crime lab delivered the news to Mr. Avery that Mr. Avery was excluded as a match for the pubic hair recovered from Penny Bernstein, and the page numbers in the book, and that he was subpoenaed, and now this is italicized, and actually deposed in Stephen Avery's lawsuit against Manitowoc County, page number, the same lawsuit in which Mr. Colborn was deposed for his role in Mr. Avery's wrongful conviction. All of these monumental points in the Stephen Avery exoneration were depicted in Making a Murderer and go directly to whether the series is, in fact, a truthful depiction of these events. Indeed, Mr. Griesbach himself appears in Making a Murderer and angled for a more substantial role in the series. All of these examples highlight that any characterization of the subpoena as an quote, obvious effort to turn a plaintiff's attorney into a witness for a prejudicial effect, unquote, blames, blatantly ignores the central role of that central role Mr. Griesbach has played in the saga that is the subject of Murderer. Please advise when you are available this week to discuss this matter by phone. She's so pleasant. We remain open to your input on whether there are ways to narrow the scope of the subpoena so as to avoid the need for formal motion practice. At this point, however, we see no legal basis for Mr. Griesbach to refuse to comply with the subpoena, and we trust that we trust that prior to our meet and confer, you will endeavor to determine which, if not all, of the objections your client will withdraw. Sincerely, Lita Walker. That was good. Exhibit 4. This is an email from John Mayer on February. God, I'm reading like crap. Friday, March 11, 2022 at 5:24 p.m. This was sent to Lita Walker. A whole bunch of people are CC'd, and the subject is Colborn versus Netflix, deficiency letter regarding Griesbach objections. It's in red here in all capitals and says external, so like a hazard. And then it says, okay, so this is John Mayer. Ms. Walker, ouch. I have no interest in raising the temperature by making threats or accusations. Exclamation point. I have no interest in arguing about what your silence or my silence means. More to the point, I had no intention of authoring an email. It was not until I received your email, which included a summary, which I did not agree with, that I felt compelled to respond. I think both of us are better than this. Setting aside the above, may I suggest that the conclusion you draw should be reconsidered. It is our job to understand and explain the law, court rules, and professional responsibility if doing so would resolve a dispute and preclude involvement of the court. I am available and would welcome such an opportunity. I don't see how it hurts you to share your views on the issues I raised. After all, you have to do this to prepare a motion, right? Thanks again for your time and have a great weekend. I will make myself available. Exclamation point. John, not capitalized. Next email from Lita Walker. Sent Friday, March 11, 2022 at 1:43 p.m. to John Mayer. CC'd all the same people. Mr. Mayer, my use of the word upshot was intentional because I did not believe it would be productive to further engage with you by providing a play-by-play of our call. I would note that you have not actually pointed out anything inaccurate in my bullet points below. With regard to your email, I disagree with everything you say, and I would have articulated my reasons to you over the phone had you given me a meaningful opportunity to speak, which you did not. It is not my job to explain to you federal law, court rules, or the rules of professional responsibility. Your behavior on the phone suggests you will insist on the last word in this email exchange. You can have it. Let me preemptively state, however, that you should not interpret my silence as agreement with anything you say. Again, I do not believe it is productive to further engage with you. Having met and conferred, it is clear to me that we need the court's involvement, and we are preparing a motion to compel. Sincerely, Lita Walker. um, from John Mayer to on Friday, March 11, 2022 at 12:20 p.m. to Lita Walker. Ms. Walker, this looks to me like a very selective summary, some of which is basically factually incorrect. I'm not sure it's helpful to explain other than to indicate the more obvious omissions. I asked you how you get around Wisconsin law that protects persons like my client. You had no response and, in fact, stated that you knew nothing about it and therefore did not consider this. Somebody wants to send me a message. Where was I? Consider this. Of course, it is a fundamental concern which is directly connected to the other issue which consumed the bulk of the conversation. That, of course, is where I began the discussion of pointing out that your requests are designed to do exactly what the federal law prohibits, which is turning a lawyer on the matter into a witness. Indeed, this is where I left the matter by asking you to address this issue. Specifically, what I stated is that my suspicion is that via the subpoena, you were trying purposely to interfere with Mr. Colborn's choice of counsel by trying to make counsel a witness. You ignored this, just as the Wisconsin law issue. I asked you specifically whether a production of any all capital document would end up violating this prohibition. You told me something along the lines of, quote, I never thought of that, unquote, much like the concern about the absolute privilege under Wisconsin law. Per this email, I am asking you why you believe these two bodies of law are not absolute prohibitions. I did explain that I would like to speak about the concerns I had with my client. But to do this, I wanted your thoughts on the federal law. So the question to restate it is whether any production, including a response that says we do not have any responsive documents, could be construed as a violation of the attorney witness prohibition under federal law. I need your thoughts on this because obviously I cannot take any step that could be used by you to support the position that my client has chosen to be a witness and therefore is disqualified as counsel. Please address this so we can consider the same. Also, from my perspective, I indicated I had serious problems with the idea that anything my client had could be considered evidence because his opinions and ruminations about the publicly available evidence could not possibly be relevant to any issue in the case. I advised that under your definition of evidence, any person, whether they be a court clerk, a juror, a judge, or anyone that viewed the Netflix production, would be a witness with evidence. Even more fundamentally, using your understanding of the law, anyone that at any time looked at any of the publicly available evidence in any way, shape, or form would be considered a witness with relevant evidence. Yes, we're in. Um, Even more fundamentally, using your understanding of the law, anyone that at any time looked at any of the publicly evidence and oh, I just read that one. Uh, 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 uh. You did not address this concern other than to ask me if I read my client's books. You further told me that you felt my client had a special relationship with the evidence, but when pressed, you refused to explain this. So we want to know how observations, interpretations, and thoughts about evidence could possibly be considered to make an issue of fact in the lawsuit against Netflix more or less true. Again, this is fundamental to our consideration of the subpoena. Obviously, from our standpoint, getting to some agreement on the above issues is a prerequisite to a substantive response. Share your thoughts on how these issues can be addressed. I indicated I could not provide you a response until these questions, particularly the federal prohibition on lawyers being witnesses, are addressed. Thanks very much. I enjoyed getting to know you and your team. We would like to move the discussion forward, so please respond at your earliest, John. But see, she's already explained it. The book she cited was written before Making a Murderer. So you can't say that everything from that book and all his research for that book is publicly available and in Making a Murderer. So he's got information not widely known. From Lita Walker, Friday, March 11, 2022 at 11:29 a.m. to John Mayer, blah blah blah. Counsel, to memorialize the upshot of our call this morning. And now these are bullet points. Your client presently does not plan to produce any documents responsive to the subpoena, though he does have responsive documents to at least some requests in his possession, custody, and control. You said he might not have documents responsive to certain requests. I asked for you to confirm that in writing. I told you Netflix would be bringing a motion to compel, but that if you thought your client might, upon further consideration, provide some documents, we would consider his position before bringing said motion. You said you would take the issue under advisement and needed to talk to your client. We asked for a date to which we could expect a substantive response to our letter. You declined to provide a date. Sincerely, Lita Walker. Um, and this is from Lita Walker on March 8th at 12 p.m. Says there are instructions to the invitation to simply call in if you prefer, or folks are welcome to keep their cameras off. Lita. And this is John Mayer to her on Tuesday, March 8th at 11:59 a.m. And he says, Lita, that's fine. I'm not sure I am familiar with WebEx. I've used a number of web-based platforms extensively, but I do not recall this one, so I offer no guarantees on a successful connection on my end. Is there a reason we need a video connection? And then Lita on Tuesday, March 8th at 11:53 a.m. says, Mr. Mayor, Friday at 10 works for me. I will send a WebEx. So these are in reverse order. I understand you need time to review the letter. So thanks for making time for the meet and confer this week. Depositions are 6 weeks away at most. So we want to make sure we can get things resolved in time for those and the potential need for the court's involvement and the time that will take is something we're trying to account for. And then he sends to her, counsel, I have no availability or Wednesday or Thursday. I think the most appropriate time would be Friday at 10 a.m. or thereafter, or Monday between 10 and 3 or Tuesday. I suspect you did not provide me your response to the objections because, like myself, you needed time just as I will need time to consult with my client in response to the material you just provided. Advise as to your availability. Thank you. And then her email to him had said, Dear Attorney Mayer, please see the attached letter, which responds to the objections of your client, Michael Griesbach, in the above referenced matter. We would like to meet and confer on the topics set forth in the letter as soon as possible. Here's my availability over the next couple of days, blah, blah. Please advise if you are free in those windows. I have copied all counsel of record on this email except Mr. Griesbach, since he is a represented party. I will direct communications about the subpoena to you, but given Mr. Griesbach is counsel of record, I plan to communicate directly with him on all other matters related to this case. Please advise if you disagree with that approach. Now we're going into Exhibit 5 to Larry Levina, Robert Herman, Greg Shetter, Todd Herman, and Andrew Colborn from Michael Riddle. Sent Tuesday, January 5th, 2016 at 11:53 a.m. Subject: forward Sykes interview regarding Netflix doc Save at Home. Attorney author Michael Griesbach, MP3. I received this from ADA Griesbach. I do not know if you heard this live broadcast or perhaps have already had it forwarded to you. Thought it may be of interest to you. Mike, Deputy Mike Riddle, Manitowoc County Sheriff's Department. Bailiff Courthouse Security. From Griesbach. Sent Tuesday, January 5th, 2016 to Michael Riddle. Subject: forward Sykes interview regarding Netflix doc Save at Home. Exhibit 6. 1. Quote, in spite of the internal recognition awards, Lenk and Colborn both came under fire at the time of Avery's 2007 murder trial. Avery's lawyers, Dean Strang and Jerry Buting, accused the pair of planting a spare key for Hallbach's vehicle inside of Avery's bedroom and planting Avery's blood inside the victim's Toyota sports utility vehicle. Unquote. Myth. In 2002, Lenk handled a box of unsecured evidence stored next door in the county courthouse building. The contents contained a vial of Stephen Avery's blood. Facts. 4/30/2002. Judge grants the motion to test fingernail clippings and hair. Quote, 6/19/2002, 12:25, opened per Hazelwood's instructions by E.J. Fitzgerald. Closed 6/19/2002, 12:27 p.m. Contains S. Avery's whole blood sample. Unquote. Nail clippings, scrapings, and hair was removed per above, see pic below, to be sent out to lab for testing. The blood vial was returned in the same box to storage at Manitowoc County Courthouse. Let me show right now, since it's here on my desk. This is the same vial that Stephen's blood had been stored. And so my husband, Jeff, has these. And so when we first watched Making a Murderer and first got all involved in this, he drew his own blood and put it in this vial. And, so this vial even says EDTA on it. I don't know if you could see that it says EDTA. Can you see? No, because it's not zooming in weird. All right. So this was done years ago. And I don't know if you can see. I'm trying to. How can I show you that the camera? Okay. The blood's dried up in there. All right. But this hasn't been opened or anything done to it since he did it years ago. Now, when he first did it, and I have pictures that I had taken of the top of this at that time, there was a for sure hole. Back up. So there's no more hole. So for there to be a hole on the top of this, the needle had to have gone in there recently. Just saying. Okay. 9/16/2002. Fitzgerald presents an amended order to transport the evidence. You know what? I've never told that to Zellner. Does anybody else think that's a big deal, or am I thinking it's a big deal out of nothing? That Jeff did this had to have been 2016 when he did this. And that he put blood in here. That this tube has EDTA in it already. He put blood in there. The blood is all dried up. It's all clumped down here. You can, but there's no hole at the top of this at all. And I should show you guys. I'll have to find it because I have it saved on my phone. When I had taken a picture. Yeah, Millbilly and Kim, right? And Brenda, I'm just thinking about this now of you don't see a hole. So, yeah, in Making a Murderer in that big thing, it was yeah, there was a hole there. We all saw the hole when it came open, and then Jeff did this, and it's like, oh, I was totally bummed, because it's like, "Yep, you see a hole." So and Kim, there were phlebotomists that said, "Yeah, there would be a hole because that's the way the blood gets in this container is there's a needle that is in here that you do it with." But now here it is, this was done in 2016, so somebody do that math of how many years ago this was. There's no hole here anymore. But you can see blood had been in here, and like I said, I've never opened it. Maybe I will send that to Kathleen. I think it's a big deal. I don't know. Um, all right, sorry, I'm getting distracted. 9/16/2002. And Jeff, if you're still on here, do you remember when you did that for sure? It had to have been 2016. Um, okay, Fitzgerald. Okay, I already did that. Um, 9/19/2002. Cause okay, see, I'm still thinking on this vial. I don't believe that Bobby Dassey is the person who planted the blood in the Rav. That just I know Bobby is smarter than a lot of the Averys. You know, you've got a lot of the Averys who aren't all that bright, and then others who, you know, are higher functioning, I guess I should say. But I still don't see Bobby being the one to get blood from the so going to where there's blood drops on Steven's sink and wetting a Q-tip and getting that blood and then going to the Rav and putting it on there. I've just that's the only thing in Kathleen's theories that I've never been on board with, and to me, it's just always been police Manitowoc that did it. How they did it, where the blood came from, that I wasn't sure on, but I always thought it was police that planted the blood, and then I totally dismissed that blood vial because there was the hole, but there's no hole anymore. All right, squirrel. Um, 9/19/2002, a quote, transmittal of criminal evidence, unquote, form is completed by Sergeant Link for the nail clippings and hair. Another document, quote, receipt of physical evidence, unquote, also dated 9/19/2002 and 15:47 hours, is completed and noted that Mike Shalou from MTSO took those items to the state crime lab. The crime lab designated the items. There's their what they were named for the hair and the nails and stuff. Receipt of physical evidence form is signed by Dolores Larson on 9/19/02. Bottom line, Lieutenant Link completed the form above for only the nail clippings hair. The blood vial was never in his hands, as you state in your article. Update. I see that you've recently edited your online version of this article to change it from, quote, in 2002, Lank handed a box of unsecured evidence, unquote, to Lank had access to a box of unsecured evidence, unquote. Thanks for that online correction, although I'm certain you won't be publishing a correction to the readers of the physical newspaper. 2. Myth. Quote, Lank, Colborn, and Remacher remained on the Avery property for several hours that day, but unlike his comrades, Lank never signed the police log documenting when he arrived that day. He only signed his name when he left. Unquote. Fact. This is accurate, except you're doing the same thing MAM loves to do. Omit the rest of the story. Lang didn't sign in when he got there because it was before the log was even implemented. No one else did either if they prior to 2:25 p.m. when the log was put in place. If you look at the log, I included the link, you'll see lots of names missing. Case in point, Remacher originally arrived at 10:59. that AM and left. Neither his sign in or sign out until he returns again from obtaining a search warrant at 3:26 p.m. that day. PM, and then a link to stephenaverycase.org, which